Hi everyone, this is Matt Osowski with the Industrial Property Team at NAI Ohio Equities, and this is the very first episode of The Warehouse Floor. Today, I'm talking with my good friend Chuck Bluestone. Chuck is a real estate and property tax attorney here in Columbus and the founder of the Bluestone Law Group. His firm focuses exclusively on Ohio property tax valuations, appeals, tax exemptions, and abatements here in the state of Ohio. So, Chuck, you know, most people get their property tax bill, they curse at it, they pay it, and they move on. But that's not really the whole story. So today we want to get into it a little bit more and talk about what property owners can proactively do with that tax bill, besides just curse at it, obviously.
Right. So nobody, Matt, should just accept the tax bill and lay down in the middle of the street and let the county and the school district steamroller over them. Property owners absolutely should be talking, number one, thinking to themselves, is my property worth what the county auditor has valued it at? And if there's some question, then they should be talking to an expert in the field about values, whether it's talking to a realtor, such as somebody here on the NAI Ohio team, or with an appraiser. And perhaps also then, if they determine that there's a question, is the county perhaps too high, then call someone like Bluestone Law Group or another law firm in the state of Ohio that practices in our field, and we'll talk about valuations. And what property owner has the burden of proof to show that the county's value is too high. And remember, I keep using the word value because, Matt, what happens, and you know this, is that when people call up, the first thing they say is, I'm paying too much in real estate taxes. But the question is the value. Appropriate. That's what we need to focus on, value. We can't really change the taxes because that's a function of levies that voters within the district have approved. So they set the tax rate, but we can focus on value. And if we lower value, the tax rate stays the same, but the ultimate tax bill will be lower. In some cases, substantially lower.
That's very interesting. That's a different way to look at it. Again, like you said, most people are just looking at that bill, when what they should be really looking at is the value of their real estate. And like you said, that's when groups like us here at Ohio Equities and Bluestone Law Group come into play. So, all right, you touched on it a little bit, but you know, let's start with the basics. You know, like you said, your tax bill is not just set in stone. So, you know, what is an actual tax appeal? And, you know, who should even really, like, what are some red flags that this is something I should be focusing on or even thinking about?
Okay, great. There are two types of tax appeals. There's a tax appeal initiated by an owner seeking to reduce the value of the property and lessen the tax burden. And then there also is something called a reverse tax appeal, and this is where a local school district or a municipality can file against the property owner seeking to raise the value. So let me talk about each of those quickly. If an owner gets the current valuation from the auditor, or whether it's a tax bill or a letter, and feels that it's too high, they should consult with someone like you, someone like me, an appraisal company. And then if they decide to file every year across the state of Ohio, March 31st is the filing deadline. There's a 2-page form. It's the same form in every county that the owner or the owner's representative, which is an attorney, signs and submits to the County Board of Revision. There are essentially two types of cases. There's a sale case where the property has sold within the last 2 years for less than the auditor's value. So, you know, you go out and you negotiate a great deal for one of your clients.
Like I usually do.
And and you score a price that is well below the county's number. This is a case that everybody should file. It's a home run. If it's an arm's length transaction, you come in pretty simple with a purchase contract. Well, number one, the advertising to show that the property was marketed, then the purchase contract, any counter offers, any addendums, the settlement statement showing what the final purchase price was, copy of the deed, copy of what's called the conveyance fee statement that gets filed with the deed. You go in, it's a slam dunk. It's a home run type of case, and relatively straightforward as long as it was an arm's length transaction. So just 15 minutes ago, I told you I was speaking with someone, and they said, well, how about if I just transfer a property to my son-in-law for a really low price? No, that's not going to work. It has to be an arm's length transaction. So we have sale cases that are tax appeals, and then there are the situations where the property has not sold in recent years, so now you need to come in with appraisal evidence. And that's where we go to guys and gals that we know, and we ask them, look at the last 3 years, income and expense statements, look at the rent rolls, look at the condition of the property, and tell us, on the tax lien date, on January 1st of whatever the tax year is in question, what would the likely buyer have paid for this property? And the appraiser will come up with an appraisal report, and we submit that. Let me switch over very quickly to a reverse tax appeal. So when properties sell in Ohio for $554,000 or more above the auditor's current value, that gives the school board now the right to request a board of revision to increase the property value, increase the tax revenues that it receives. But it has to be at least $554,000 above the current auditor's value. The school board will send a letter to the property owner notifying the property owner of its intention to file a tax appeal. At that point in time, the property owner should call their counsel and say, hey, this is coming, let's get ready, let's talk about this, let's prepare for it. And then generally about 30 days later, the school board files the actual formal tax appeal, and then the property owner has 30 days to respond. In those situations, there's typically an arm's length transaction. So this is where somebody else has represented the property owner,
the seller,
and they've represented the buyer, and they haven't done as good a job as you. And so let's say that the property owner the new owner paid a lot of money above the auditor's value. This is when they call us up, and we can try to find technical flaws in the school board's case and get it dismissed. And that has happened over and over again, surprisingly.
Yeah.
They mess up. Or if they haven't messed up, then we can try to negotiate. And in fact, today, just settled a case, property in a major retail core area of Greater Columbus, and it's a strong property, and we got a great settlement for the property owner. We avoided close to $100,000 of additional taxes. So in that case, yes, the owner did wind up paying some additional tax, but we avoided $100,000 more.
Yeah.
So in both circumstances, we were able to assist the property owner.
That's a great explanation. I'm a property owner. I'm sitting here. I'm wondering if my taxes are too high. Is there, obviously, we discussed the reverse appeal, how the school board has a barrier, can then file with the Board of Revisions. At what point, everyone thinks their taxes are too high because they're just there. Sure. But at what point should a property owner be saying, yes, my taxes are too high, I need to call Chuck?
Okay, so I'm going to talk for a second because some of the about a residential situation, because some of the people that are watching may own a home.
Absolutely.
So I would tell you, generally speaking, $50,000 or more in reduction is where a single family homeowner should call our firm. We will then get the property appraised. On a home, it's around $500 or $600 typically. On a really big home, like 10,000 square feet, it may be $1,500 to $2,000 to get an appraisal. But generally speaking, on a single family home, $50,000. Even for an investment, because people own Airbnb homes.
Yeah.
$50,000.
$50,000 is kind of the...
Right. I would tell you on a commercial property, we're looking at probably a minimum of $100,000. Now, if it's a sale case, I'll take any number, less than the auditor's value. But if we have to get an appraisal, it's going to be at least $100,000. Why? Because $100,000 in value reduction translates typically to about $3,000 per year in tax savings. And there's an expense of having an appraisal, and I work for just a dozen eggs or a chicken. But sometimes we do have to charge a small, very reasonable fee. We want to make sure that the savings are going to be more than the costs.
Right.
So if I have 3 years of tax savings and I'm getting at least $3,000 a year, that's $9,000. That would certainly cover the appraisal fee, and maybe there's a couple multiples of this.
Yeah.
So we're dealing with $18,000, $27,000, or maybe $100,000 of savings. It's going to cover the legal fee as well.
Yeah, is the juice worth the squeeze? right?
Exactly right.
Yeah.
Right. And I think I told you in the past when we've talked that 2 out of every 3 people that come to us, I decline to take the case. The first person who comes, and it just happened today. A major developer in town built a project, costs were $35 million. The county's valuation is $25 million. And he said, I'm paying too much in taxes. But we cautioned the owner and said, got to be careful because you're going to have to disclose the construction costs. And we don't want to go down there and it bites you in the behind.
Yeah.
So
this has an opposite effect.
Right. So we have to be careful. So we tell the first person, don't raise your hand. Don't try to attract attention. The second person, there isn't a lot of juice. And so we look at it and we say, hey, these are the costs, these are the potential returns.
Yeah.
But when you file a tax appeal, you open the door for the school board and for the county to come in and say, we think it's worth even more.
Yeah.
And we don't want it to backfire. It's not worth the risk. But in the third situation where either there's a recent sale or we have good appraisal evidence, or there's a circumstance where part of the building burnt down, or there's mold, or there's flood damage, or a windstorm, or it collapsed, or the owner tore down the building voluntarily. For example, there were several regional malls here in Central Ohio, Westland, Northland, Eastland.
Yeah.
There, I think, at least 2 out of the 3 are gone, and the third is on the way out.
I'm sure.
So when somebody knocks down a structure, it may be an opportunity to get that building value off the tax roll.
Got it. Okay. You've touched on this a little bit, but when somebody brings you an appeal, can you? So I come to you, and I've done this before. I've called you before, and hey, I have a client who this is what he does. Can you give a sense up front, like this has a high success rate, or you know what? Don't even bother messing with this.
Yes, we answer phone calls from owners all week long.
Right.
And do a very quick 30-minute discussion with them and get some basic facts. Explain to them what the burden of proof is on the property owner, what we need to come to the table with to show the county tax board, and then we talk about the history, ownership, and the financial performance of the property. We do it all the time. And let me just say, anybody who's listening to this program, who's a client of NAI Ohio Equities, call me. There's no charge for that initial consultation.
That's fantastic. Thanks, Chuck. So we touched on this, but what evidence actually moves the needle? So obviously an appraisal, we talked about that. An MAI appraisal is going to have a lot of bearing. I get these calls all the time for BOVs, whether it's for a bank or whatever it is. Does that evidence help the case, or what other evidence?
A BOV is helpful in making the preliminary determination whether or not to pursue an appeal. But a BOV is not an appraisal because you're not licensed by the state of Ohio as an appraiser.
Correct.
And therefore, owners who come to the tax board with BOVs and that's it, will lose.
Yeah.
Yeah. Now, if it's John and Mary Smith and they have a house in Worthington and they come in with a broker's opinion of value, the tax board's going to be a little bit sympathetic, but on a commercial property, you have to have an appraisal.
Right. Makes sense. So we know March 31st is the deadline. Here we are recording this in January, so timing is of the essence here. We were talking about this before we started the interview. When should somebody be reaching out to you? What are some other timelines? How long does it take you to prepare to meet that March 31 deadline?
Yeah, I will tell you that the sooner the better, because it gives us the time for really thoughtful analysis. I have had people call me at 7 p.m. on March 31st. So the office is technically closed, but we're there working into the night, and we have to get, and if it's not in county, we may have to get the letter sent by certified mail, postmarked by midnight, March 31st. I will tell you that sometimes I've gone to extraordinary lengths to find somebody at the post office, knocking on doors to get that stamp. But the sooner the better, because it gives us time for thoughtful analysis.
That's good. Okay, we know what's going on. Let's decide. I'm going to move forward. You walked us through the process. When can I expect a resolution?
Sure.
If I meet my March 31, when can we expect things to be done?
And Matt, it's important to understand that by the March 31st deadline, there's the requirement to file the 2-page form. You got to buy the lotto ticket on time to win the lottery. So you file the 2-page form. The appraisal, the sale documents can come later. You got a couple months. Here, what happens is the county will, for the following 30 days, be processing the paperwork, entering the data into their computer system. Then typically the school board has an opportunity within that 30-day period on a commercial property to respond. The school board will ask very simply that the value be kept the same, that there be no diminution in taxes paid to the county and to the school board. And then generally speaking, in small counties, hearings are held between June through September, so over the summer. Okay. They're usually 30 to 40-minute hearings, although there are some circumstances where I've asked for an hour, but they can be relatively quick. In the bigger counties, Montgomery County, Hamilton County, Franklin County, Lucas, and so on, Stark, Summit, Portage, you're probably looking at hearings from September to December. The only exception really is in Cuyahoga in Cleveland, 1 year. Oh, so if you filed March 31st of 2026, typically you'd get a hearing in 2027 up in Cuyahoga County. Now, I get paid when the client's cases are heard and resolved. So I have a strong motivation to propel these cases to this hearing as quickly as possible. So we are on the phone, trust me.
Right.
We're on the phone, calling the different counties, right? Calling the different counties saying, hey, we're ready.
Yeah.
And we want to have a hearing. Particularly up in Cuyahoga County, we have a great relationship with them. And I'll call up and say, I don't need 30 or 60 days prior notice. Give me a week, because I'm ready to go.
Yeah.
And I can just want to make sure my appraiser and my client are ready, and we're going to show up. Typically, we go in person to the hearing. There is an option in probably every county to do a video or Teams, a Zoom type meeting. It's not as effective. It's particularly when it's the property owner asking for a reduction. I think it shows respect to go there in person and say, they want to hear, I want them, my client to talk to the board and say, I understand I have to pay taxes. I'm willing to pay taxes. I want to pay taxes so I can get the basic government services, but I want to be taxed on the property's fair value.
Right.
And the current number is not fair, and I'm here to ask for reduction. Going in person also allows them to judge the sincerity of the witness. They can see the property owner's tone of voice. They can look into his eyes. There's gestures, that we all absorb as we're talking to one another. That if you're on a Teams hearing, it's just not as effective. Occasionally, if it's a small case, we'll do Teams. Instead of a 6-hour drive, because it saves the client money.
Sure.
So there's a little bit of balancing. But typically, we have the client come, talk about the sale, if it's a sale case. Sometimes we have the broker come and talk about the marketing of the property,
how they marketed it,
and the negotiations, and what other properties were available on the market. And then on an appraisal case, we'll have certainly the appraiser, because the report is a hearsay document unless the appraiser comes.
Right.
So the appraiser must be at the hearing. And sometimes we've had a real estate agent come and talk. Can I give you a funny example?
Sure.
Recently, we had a client who had a 3-story building in Bexley, a suburb of Columbus on the east side, right on East Main Street, right retail on the street level, 2 stories of office on top. We presented an appraisal report from a very qualified MAI appraiser, and the school board came in with their own appraiser. And the school board guy said there were 506 office and retail buildings in Bexley, but not a single one of them is germane to my analysis of this property that's located in Bexley. He looked at properties in the Bridge Park district of Dublin. Don't laugh. And the Short North.
Yeah, it's different.
And he said there was not a single realtor building available in Bexley that was comparable. Well, now you have 2 competing appraisals, and the board has to decide which is right. Well, we decided to call a rebuttal witness, and we called a realtor for a competing property, which was retail on the street level, 2 floors of offices atop, across the street. And I
think I know the property.
Okay, and he said, you probably do. He said the school board's appraisers report didn't hold water. that there were lots of retail properties up and down East Main Street that could have been used as comps, just like our appraiser used, and to compare the property to Bridge Park in Dublin was comparing a orange to a giant watermelon.
It's not
comparable.
It's not comparable.
So the realtor came in helpful that way as well.
Yeah, that's really good. All right, kind of a little bit of a trick question. It's probably really, you might have a short answer for this, you might have a long answer. We deal with a lot of tenants. In a triple net lease, the tenant's paying their proportionate share of their taxes and the operating expenses. But the landlord's actually the one paying the tax bill.
To the county, right, typically.
Typically, unless it's a freestanding building where the tenant could be paying directly. What could a tenant do to proactively work with a landlord on a tax appeal? And could a tenant apply for a tax appeal, or must it come from the landlord?
Okay, a tenant can, under new law that's been in effect now for 2 years, a triple net tenant in a standalone building where the tenant is responsible for paying the taxes or has permission from the landlord to file a tax appeal, that single tenant, triple net tenant can file a tax appeal in their own name. This is new law that's only been around for approximately 2 years. In the situation, let's say, where you have a retail inline and there's 3, 4, 5, 10 tenants, and they're all paying CAM charges, a component of which is the real estate tax bill, a proportion for them. No, they can't file in their own name. So they should go to the landlord and file. Only the landlord can file in that situation.
In those situations.
Yes.
I did not know that about the single tenant buildings though. So that's
it's new.
I never heard that. So that's fantastic.
I'll tell you a great example.
Yeah.
A McDonald's, for example, I represent that company for 25 years. They can now file in their own name.
When they're a tenant, obviously.
When they're a tenant, yes. Or a CVS. They can file in their own name when it's a standalone building. Or a daycare.
Yeah. Or any industrial tenant.
Or any industrial tenant, right.
As long as it's a freestanding, you're paying the tax bill directly, essentially.
Or you have permission from the landlord.
Got it.
Yes.
Okay. Fantastic. That's good. Okay. Here's a big question that we're going to get asked. What does pursuing a tax appeal actually cost?
Hopefully it pays for itself in benefits many times more than the costs. There is some owner time because the owner has to be involved, has to open up the building and allow people to walk through and do inspections. The owner has to turn over records, and sometimes the owners don't want to do that because no matter how much they complain about the tax burden, they're actually doing really well at the property. Let's say it's a hotel. They're doing really well, and so you're selling the building to overnight guests, and they don't want to show the books. So you have to, and when you show the books to the county and the school board, it becomes a public record. So owners sometimes value the confidentiality it's cost. Typically, in terms of appraisers, I would tell you fees would range typically between $2,500 for a small commercial building to maybe $7,500 for a bigger commercial building, and for something that's a major downtown structure or major manufacturing plant, $15,000? Maybe. But that would be a high appraisal cost. Appraisers have to charge a flat fee or an hourly fee. They cannot charge a contingency fee.
Right.
In contrast, our firms and many attorneys charge a fee that could be done on one of three different bases. Either a flat fee, and we have, based upon experience, knowledge of typically what it's going to take in terms of time and the complexity of the case, so we could do a flat fee arrangement, or we can do a contingency fee arrangement, and we do those, where we're seeking a reduction, or we're seeking to block the school board from an increase. We'll take a percentage of the savings, and sometimes we do cases on an hourly fee basis.
Got it.
And I think that that's pretty standard across the board for law firms in Ohio.
No, appreciate that. Okay, we're nearing the end here. So last question, what are the biggest mistakes property owners make? And as we're kind of heading into tax appeal season, what's your best piece of advice?
Okay. There are some circumstances where a property owner can file a tax appeal themselves, whether perhaps they own the property in their own individual name, or they're an officer or director of the LLC or the corporation. They're a salaried employee of the company. They're the general partner in a general partnership. I told you that the form is 2 pages. It's, I think, 15 questions, but it is filled with landmines. And if you don't fill out the form correctly, you get bounced, and you may not be able to get a reduction at all for that year. And potentially you may be screwed out of getting a reduction for 2 or even 3 years. So there's a risk. Property owners oftentimes, many times, don't know what is a convincing argument. They'll say, for example, this is very common, hey, the building across the street is valued per door less than what my property is assessed at. And a mile or two away, there's another property that's valued less than my property. The problem is those other structures, those other properties, A, have not gone through a recent arm's length transaction, most times, and B, there's nobody who can make the comparison because the owner is not an appraiser. So what property owners do is they try to come in with a BOV. They print property reports ad nauseum from the website. Okay? And it's just not probative, reliable, convincing evidence. On a commercial property, hiring an attorney is really the best advice. Somebody who's experienced in the field, and there are a lot of good attorneys around the state who have experience. I hope everybody calls us, but we have many colleagues who do a good job.
Yeah, that's great.
The biggest other issue is focusing on taxes paid, not value. Okay, we talked about that before, I'm not going to repeat it. And thirdly is not thinking ahead. So somebody may say, we get phone calls, and one of the questions we ask are you planning on selling this property? And they're like, yeah, I'm going to put it on the market in 6 months. Well, Matt, I would much rather that the property owner have a high value as far as the auditor is concerned and pay a little bit of extra tax now, but the value might be $500,000 or $1 million or even $2 million more than the true market value. The first place, and you know this, the first place that a potential buyer is going to look is the auditor.
100%.
Right. So it's better if the owner is intending to sell the property within the next year, keep the value high, pay a little bit of extra tax, but get a bigger bang for the buck when they go for the sale.
That's great advice. That's great advice. Chuck, this has been great. Really appreciate your time. Thank you everyone for joining us on our first episode of the Warehouse Floor Conversations with the Industrial Property Team. And thank you to Mr. Chuck Bluestone for his insights and time today. If you have any suggestions or other featured guests you'd like to see, please let us know. And remember, every deal is different, so stay informed.